Hello, everybody. Good to be here. Still got a little bit of a tummy ache, but that's all right. I'm here. And so is Ava. She made her grand entrance, as she typically does. Come on, baby. So, yep. Hello. How you doing, April? Good to see you, love. Yep. Just me and Ava at the moment. She's happy to be here too. I got a few nifty clips that I came across yesterday and today. So I thought that I would pop on a little later than normal. Hi, Sherry J. Oh, thank you. And thank you for coming. All right, baby girl, go lay down, sweetie. We'll find a comfy spot. I turned her heater off, so now she's wants to crawl under my feet. So, aww. Hi, Tink. Tink, 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 tink. I'll get her a little tail wagging. I'm so happy Tink's doing all right. She's a good girl. Cute, cute little fur baby. We gotta have our babies. Hey, Paula. How you doing, honey? Glad you came. It's so good to have you. Just getting ready to put something on. Hi, Linda. How you doing, honey? I'm glad you made it. Yeah, yesterday I just was not feeling good. I'm still like, yeah. So if I get up and go off camera, it's because I still have a little bit of a tummy ache. But yeah, I wanted to come on. I felt good enough to come and hang out with you guys, at least for a bit. Hi, CE. Good to have you. Yeah. Yep, always. This is my favorite part of my day. So, I was going to be here I'm always going to be here if there's any chance that I can, Sometimes I just can't, though. We all need a day off once in a while. I'm glad you feel better today. Yeah, being sick's no fun. Yeah, I wouldn't be here if I didn't feel better, at least somewhat. I did debate on it, I was like, should I take one more night and just, sleep this off? And I was like, I'm going to be up for a couple of hours now because I'm late because I laid down and I set my alarm. Apparently, my alarm went off and I must have just dropped my phone on the floor when it did, because that's where I found it. And it was on the alarm screen. So I must have just clicked the dismiss button and passed back out. But So I got a couple of hours of a nap in. So a little bit, enough to be here. Good to have you, honey. And thank you. Hiya. Welcome to the party. This is where the cool kids hang out. Oh, yep. That's where I am too. Mine was a couple of hours, so. Oh, yikes. Oh, no. I hope you're able to, still get the sleep that you need. I know the day that I had surgery, I stayed up the whole night and then I slept under the anesthesia. Fake it till you make it. No, I'm okay enough. Like I said, if I if I go off camera, it's just because I'm still not 100%, but I'll be back. You might just have to entertain yourself if the clips stop, but yes. Yep, that's exactly it. You get a much deeper sleep under the anesthesia anyways. You're helping them out. All right, let me see what I got. I'm gonna put something on. Let's entertain ourselves. Oh, this is kind of cool. I caught this. This is 2 separate hearings. The first one's not anything, super exciting, but it kind of sets it up for the second one.
All right, we're here on 2 files, 23132221 FH and 23132210. People of the state of Michigan versus Eric VanZant. Looks like we've got pretrial conferences and motions to bond. What would you like to do first, Mr. Diegos?
Court's preference, Your Honor. I can address the bond motion ever so briefly on top of the pleadings. Had an opportunity to speak with my clients some further. We did acknowledge in one of the paragraphs in their motion the prior history of failing to appear upon my information and belief. You just wanted me to clarify that at the time that happened in those minor traffic offenses, there was also an issue with his minor child that involved a abuse and neglect proceeding. His failing to appear was not reflective of his desire to avoid ramifications of the criminal justice system. It was, again, both oversight and a poor choice on his behalf in terms of prioritizing. I think I addressed the relevant facts. There's a lifelong community resident. He's adamant in his opportunity to present his case to a trial and to a jury in this case. No desire to run. Very concerned about his child, who is at this time in the care of his elderly parents, as we outlined. So I would ask the court to consider all of these considerations, as well as what we've outlined in the motion for bond, and consider a reduction in this case. Certainly, if the court believes that our prayer for relief is excessively light, we would still ask for the court's grace in fashioning an amended bond, otherwise based on the pleadings and these considerations. Thank you.
Reasons.
I don't remember, I don't know if it's in your pleading. How old is the minor child?
She's 16. I've had it back for about a year and a half, maybe a year.
All right, Mr. Stan.
Your Honor, we did file a response. I think the main points here are the seriousness of the offenses. These, I'm talking about the factors of 6106 and also the defendant's history of non-appearance. These are serious offenses. The defendant does not show a history of following court's orders. We had the PPO hearing, and he had also failed to appear for over a year, I think, on a bench warrant out of district court. I think the court should deny the motion.
Did you want to address the seriousness of the offense? I see what the charge is, but I don't know anything about the underlying facts. We see that there's some reference to acts, which doesn't sound good.
Does the court not have a copy of the preliminary examination?
I haven't read that.
Oh, okay. If I could have one moment, Your Honor. I did not run it, but I do recall it. Yes, Your Honor, it's a fairly lengthy fact pattern.
Well,
I would ask that the court maybe look at that transcript, because I don't want to soft sell what happened here.
well, Mr. Nagos, does your client have any ability to post any amount of bond?
Just a second on that. Now, my client did indicate to me before, and I just wanted a moment to confirm, he is an owner of the address referenced in here, so he would be working to essentially put up his house. He's not unsure how much value it would be, but to answer your question, he can put up something.
All right, well, the court is going to deny the motion for reduction of bond. We are dealing with two different files. 2 counts of 10-year assault with intent to great bodily harm, less than the crime of murder. There's allegations of a felonious assault with an axe, unlawful imprisonment, a couple counts of that.
Oh, that's right. Your neighbor's an axe assaulter.
This is habitual offender 4th, so these could be life offenses, and the other one involves firearms. So, given the violent nature of these offenses, his prior criminal history, and his failure to appear, the court does find that the bond is reasonable to protect the public and to assure his appearance in court. So then, turning to the pretrial conference. Mr. Stay, was there any offer that you were going to make in this case?
Still have a pending offer from June 20th, 2023, if the court would like me to put that on the record.
Yes, please.
On 23-13210 FH for the defendant to plead guilty or no contest to count 1, 2, and 5 with an habitual offender 3rd offense notice. People move to dismiss the balance of the charges on that case. Guidelines 43 to 129 months. People would cap at the midpoint of the guidelines. Those charges would be concurrent with each other and concurrent with 23-13221-FH. The offer on that case is for the defendant to plead guilty or no contest to counts 1 through 3. The people will move to dismiss the balance. Recommend sentence within guidelines on counts 1 and 3, which are 5 to 23, and count 2 carries the 24-month consecutive sentence, which would be consecutive to count 1. 1 and 3 would be concurrent with each other and concurrent with 23-13210-FH. And this is a situation where the defendant must plead on both cases to gain benefit of the entire agreement.
Okay. And Mr. Niagos, has that offer been conveyed to you?
Yes, sir.
Did you have an opportunity to discuss that with Mr. VanZant?
We did discuss it in the past, Your Honor. At this time, my client wishes to go forward towards a trial in this case.
Okay. We have a trial date in either one of these cases yet. 2 separate trials?
I would ask at this time, given my calendar, I would ask to set the case with the higher guidelines. I'm sorry, I don't have the case number in front of me first, and then depending on that outcome, consider resetting the second case, or it could resolve.
As to the court's first question, I think they should be kept separate at this point. There was a search warrant done after the report of the assault that yielded this barrel, but
Thank you. I misunderstood, but thank you, Mr. Stay. I agree with that.
Okay. So we'll set 2313-210. That's the one with the assaults and false imprisonment. We'll set that for trial March 19, 20, 21, and 22. And we'll set the other one April 2, 3, 4, and 5.
All right. I apologize, but that week I've not gotten around to sending my customary email. I think that's spring break week in Muskegon, and my family and I are going to be God willing, out of the country.
God willing.
Okay. Well, I'll have to get you a different date for the second one. Are you available for the March date?
Yes, sir.
Okay. Well, I'll have to get, I only have a couple dates here, so we'll give you the trial date on the other ones. And if I recall correctly, I think we've been in contact regarding trial dates. I think we offered some originally January, February. Is that correct?
You have, Your Honor. Your court staff's been very accommodating with me. January and February is, at this time, nothing short of a disaster without expounding any further. So these dates in March are not only, they're very kind, and frankly, the earliest I can do.
Okay, all right. Is there any point in having a final conference?
I believe there is, sir.
All right. How about a final conference December 18th at 1:30?
Thank you, Your Honor.
All right, that's all for today.
Yeah, he's a lovely gentleman. False imprisonment, assault with an axe.
All right, this is Eric Lee VanZant. We have him on two files, 2313210, 2313221. I think both these cases are set for final status conferences. And Mr. Stay, is there a final offer that you're making in these cases?
The offer is still as follows. On 23-13210 FH, the offers for the defendant to plead guilty or no contest to counts 1, 2, and 5 with an habitual offender third offense notice. The people would move to dismiss the balance of the charges on that information. People calculate the guidelines at 43 to 129 months on the minimum. The people would cap at the midpoint of those guidelines. That would be, those charges would be concurrent with each other and concurrent with 23-13221-FH, where the offer would be for the defendant to plead guilty or no contest to counts 1 through 3. The people would dismiss the balance of the charges on that information. Recommend the defendant be sentenced within the guidelines on counts 1 and 3. So the people calculated 5 to 23 months on the minimum. Count 2 would be the 24 months consecutive to count 1. 1 and 3 would be concurrent with each other and concurrent with 23-13210-FH. And again, the defendant must plead to both cases to gain the benefit of each individual part.
Now, all of that was lawyer speak for, this is a good deal for you. You should take it and not go to trial. But Mr. VanZant does not like the offer, and he's not fond of his attorney.
All right, and Mr. Nagos, have you had the opportunity to discuss those offers with your client?
I did, Your Honor. At this time, my client is desiring to go to trial on both files.
All right. And Mr. VanZant, you understand that after today, your option is going to be plead guilty as charged or go to trial as charged, that you will not, the court will not accept a reduced charge or any sort of sentence bargain going forward. Do you understand that?
No, I don't.
All right, well, I just told you. Do you understand?
No, I
that?
don't. I don't understand either.
Okay,
This case is just going their way, the way they want it to go. There's more to this case than just all that. There's things I've asked for chest cameras. I've asked for several things on it. And now you're taking me to trial on both of them. They even show me nothing. My guidelines are still the same.
Mr. Nagos, is there some outstanding discovery?
Your Honor,
Sir, I wasn't talking to you. I was talking to your attorney. He speaks for you. So, Mr. Nagos, is there any outstanding discovery?
Your Honor, to my knowledge, I've received all of the available discovery in this case. There is extensive video footage available in this case. I think I've probably received somewhere in the neighborhood of 26 to 28 separate emails containing various footage from law enforcement officials. I don't have any reason to believe there's any discovery outstanding. I believe what my client's referring to is the fact that I've been unable to yet make the time to review some of that footage as it pertains specifically to case ending in 221, in terms of the length, so to speak, of the weapon that gives rise to count 1 in that case. But in terms of the case that's 210, that's really the controlling case in terms of Mr. VanZant's guidelines, and that's the case that's set for trial in March. I don't have any discovery issues at this point in time.
How long have you been on the case, Mr. Negos?
No, I have been on the case since sometime in September of this year,
Okay.
end of September, Judge.
You haven't gone over those videos with Mr. VanZant yet?
No, Your Honor,
Why not?
I just haven't had the time to do so yet.
Okay. When do you think you're gonna have time?
I mean, it's certainly, especially given our discussion today, a priority in my schedule.
This isn't the first case that I've told you. I mean, after the final status conference, you know from other cases that basically that's it. This is done. People need to have finality. He needs to know the best offer that he's gonna get. And the people need to know whether they're going forward.
I understand that, Your Honor, that the offer was communicated and has been communicated from the very get-go, and there was nothing in the videos, one way or another, that would change the offer. I've had extensive discussion with Mr. Stay in terms of the review of the videos. Again, some of the information that Mr. VanZant's now addressing the court about, that's really pertaining to the case that's not set for trial until May, and one that, again, I've explained to him at length, is really, in the simplest terms, absolutely secondary or of little to no consequence, depending on what happens with the first case, the controlling case that gives rise to the very high guidelines that Mr. Stay placed on the record, the assaultive case with the victim, Stephen Pike, or the complainant, Stephen Pike.
In other words, my client is guilty as sin. He was given the only offer he's going to get. The video is not going to exonerate him. And the case that the video pertains to is the secondary case that doesn't really have a bearing on the time that he's going to serve. I understand why the lawyer hasn't made it a priority. I mean, is it wrong? Yeah, maybe in lawyer world it probably is. But the guy doesn't have a case, and but it seems like the judge has history with this lawyer that I don't know if defense attorneys may be the right avenue for this guy. Maybe he should switch over to prosecutor.
And in all of my discussions, there hasn't been a single.
No, it's just been your way. You ain't done your job.
Hasn't been any indicia of any type of desire to take any type of plea offer.
All right, fair enough. These cases are both set for trial. We'll go forward as scheduled.
Thank you, Your Honor.
That's all for today.
You gotta come see me. You know what I mean? This isn't just sending mom girls on. Not one of your kids.
So I had to leave that little bit in there. So not only is he very unhappy with his lawyer, but now after basically saying, my lawyer's incompetent and isn't doing his job, then he walks away saying, well, you're going to come see me, right? oh yeah, he's gonna come see you, and now that he's been admonished by the judge, he's gonna show you your videos, all 26 emails of them. And it's probably not even that the lawyer didn't watch all of the videos that mattered. He probably just didn't watch all of the angles. You know, it might have been like body cam 1, 2, 3, 4, you know, and so he watched a couple of them, and there wasn't anything really to glean out of the other couple, so he didn't watch those as thoroughly or something. I kind of feel for the lawyer, because what do you do when you get a crappy client? I mean, you're supposed to defend them to the death and, do everything you can to get them off, but I don't know that I could. That's why I'm not a lawyer. Let's see here. I also found we have not seen this wonderful lady in a while.
Hello, Miss Pilkowitz. Are you here on Miss Somerville?
I am. Is she present in your courtroom?
She is present, and I can call her up. But Miss Pilkowitz, did you get a chance to review this pre-sentence report?
I did. I found it strange. I will make my record. Obviously, if the court is inclined to deviate from the sentence agreement, then Miss Somerville would have the right to withdraw her plea. I think we can come up with something amenable to all parties based on certain requirements and conditions of probation. So that was going to be my proposal to the court. But I did see that the probation department is deviating from the sentence agreement. And just by way of preview, my proposal was going to be, in lieu of drug court, perhaps we just have her on probation, order her to complete outpatient drug treatment as a condition of probation, which I would think would be functionally serving the same purpose.
Sounds
All
right.
right. Yeah, let me just see what the plea was. I mean, what the plea form indicated. I have just pleads no contest under 771. Drug court recommend probation. So she was to go under, she was to be reviewed for treatment court, but it doesn't look like she's been very cooperative. Or, ma'am, can you come on up? Yes, Miss Somerville.
I love this judge.
Yes.
Yes, please. All right. So let's just call it. This is 23-1997 FY, the people versus Tammy Somerville.
Hopefully have on our behalf of probation. If I could, Judge, the reason for, the deviation away from the plea agreement is because for the plea agreement, we can't do both things. We can't put her in drug court under the 7711 in a no contest plea. So I, after screening her, feel that she does need drug court, but I can't recommend that if the plea is under the 7711 and the no contest.
So it's a no contest plea, Ms. Pilkowitz, and under the program rules, she can't go in under that status.
Your
And I'm listening.
I spoke with the probation department about this. So, well, first, I'll put my appearance on the record. Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Miss Tammy Somerville. So prior to the probation department rendering this PSI, I spoke directly with the probation agent assigned to this case. I anticipate it's the same person who is currently in your courtroom, although I can't say that for certain. And essentially, the probation officer explained under 771, we can't do drug court. 771 gives you a 1-year deferred dismissal. Drug court is a 24-month program. And she proposed, this is what was told to me, was that, Miss Somerville can withdraw her plea, or we can proceed basically sentencing her, and I proposed just to the 1-year probation as envisioned under the plea agreement, which is what's appropriate, and not do drug court. as drug court to me was not a requirement of the plea. It was drug court if recommended. So the way I read the plea agreement is 1 year probation under 771. If drug court, if she were eligible and it worked out, great. But we understand that it's a 2 year program that was not called for in the plea deal. So what I would propose at this juncture is a 1 year sentence under 771 with drug treatment outpatient as a requirement of a condition of this court. I think that is the appropriate remedy. Alternatively, if the court is not inclined to sentence her to probation, again, we'd be moving to withdraw the plea.
Okay,
So I did speak to her prior to the PSI when I saw the.
when you say her, you mean Ms. Pilkowitz?
Yes,
Okay.
sorry, Judge. So yes, I spoke to the attorney and this is for the PSI, and I said that we cannot go forward with the screening for drug court with this plea currently in place under 7711. So the attorney recommended that she keeps her plea at 7711 instead of withdrawing it for the drug court eligibility screening. I went forward with the screening. I do not deem that she's an appropriate candidate for anything other than drug court. So if she wants to keep the plea under 7711, I can't.
Well,
make a
even if,
recommendation
here's
for
the
probation.
problem is trying to get her into, look, even if I said, okay, look, here's the reality of it. She got a felony reduced down to a misdemeanor for the plea, right? My bigger issue is she takes no responsibility and she doesn't think she has a problem. So the problem with getting her in treatment, Ms. Pilkowitz, is I presume she's gonna need some, she's gonna have to be assessed by DWIN. When she goes downstairs and calls DWIN and says, I don't have any problem. There's some family history and I use this drug, but I don't have an addiction or any problem. She's not gonna qualify for any sort of treatment. So that's the bigger problem, is she doesn't qualify for treatment under DWIN's guidelines. So if she doesn't think she has a problem, we can't give her outpatient. I can't order outpatient treatment because she won't qualify for services.
And Your Honor, what I can say is I can have a frank conversation with my client. I can have my social worker, assist my client in basically recognizing that there is in fact an issue and to help her actually get.
No, she's shaking her head. No, she doesn't have an issue at all. I mean, the report kind of speaks for itself, in my opinion, but she's indicating she doesn't have one. So I'm not gonna.
And that was also the reason for my recommendation, Judge, because, I feel that there is a substance use issue with the screening, but the defendant does not. I'm not gonna go forward with drug court and also with the plea. And then what you said as well with the standard probation.
Excuse me, Your Honor, can I say something?
Oh, hang on, Tammy. I want you to. I have Ms. Somerville give me a call.
Yeah, your attorney wants you to go call her.
Okay.
You shouldn't say anything on the record, ma'am, because anything you say can be used against you.
I can bring my phone and I don't have her number on me. And
Tammy,
Do you want to write it in the, write it?
it's my work number. I'll read it aloud into the record. I'm good.
Okay.
I'm not worried about who's gonna be blowing up my phone. We're good.
All right. Oh, you got it. Okay.
ma'am, something, John, I don't have a vehicle and I'm trying to sell my riding lawnmower that I paid for $3,600 for to get a vehicle. We're supposed to be doing a barter. So I don't have transportation. I gotta call people just to come to probation and stuff. You know what I mean? So
All right, Ms. Pilkowitz, you want to talk to her real quick? I'm going to allow you to withdraw the plea because I don't see how we move forward on Ms. Somerville's case other than a plea withdrawal, to be honest. Because I don't think you're going to change her mind out there and to convince her that she has a problem. And now she's indicating she doesn't have transportation to, do anything anyways. But I'm gonna let her call you and we'll set this aside. We'll pass this for a moment.
thank you, Your Honor.
All right.
Oh, but it gets so much better.
The opportunity to speak to her attorney.
All right, come back on up, ma'am. Ms. Pilkowitz, are you ready? We're back on Miss Somerville, Tammy Somerville.
Am I okay to leave?
You are, sir.
Thank you.
Yeah. Bye-bye.
Yep.
Bye, Christopher.
Okay, Ms. Pilkowitz, did you speak with your client?
I have, Judge. She's going to withdraw her plea at this time.
Okay. So, I mean, I don't really see another option, and I'm going to grant that because I can't get her into treatment court. She doesn't think she has a problem, and you know, the recommendation obviously makes sense, but the recommendation is contradictory to the plea, so she has a right to withdraw it if I'm not going to follow what the recommendation was. So we're going to go ahead and, ma'am, is that what you wish to do?
Yes, ma'am.
You want to withdraw your plea of guilty?
Yes, Your Honor.
And you understand, ma'am, that if you withdraw that plea, one of these counts is a felony. You understand that?
Yes, ma'am.
All right, and that felony, so we would set a probable cause conference date. She has that count one, which was a 4-year felony, Ms. Pilkowitz, so we'll just set a PCC date and an exam date to move forward on the charges.
Another
Understood, Judge.
idiot.
All right, 1 second, ma'am. So ma'am, is it your desire to withdraw this plea?
Yes, Your Honor.
Understanding that that felony would come back up?
Yes, Your Honor.
All right, so, okay, the plea's been withdrawn. Okay, and then Ms. Polkowitz, you want to look at your calendar? Well, let's see if we can find some dates here.
Yes, Judge, this case, I believe, was originally in front of Judge Slavin. I don't know if it goes back to him or if it stays in front of Your Honor.
It got switched to you, Judge, when it was.
When it was a
the drug
possibility of
eligibility.
treatment court. So now that she's been rejected for treatment court, would it go back to Judge Slavin? I mean, once it's been transferred, I think it's been transferred.
Yeah, I think it should stay with you, because, I mean, depending on
Yeah.
what the outcome is, I mean, drug court might not.
Yeah,
be
Ms.
completely off the table.
Yeah, Ms. Polkowitz, I think it stays with me. If the court administrator or tells me differently, I'll let you know.
Understood, Your Honor. Did the court want to set a PCC date and an exam date or just a PCC date?
If we can, well, let's set a PCC date for sure. We have a prosecutor Mondays from 9 to noon. She's out of custody, so her bond will continue.
I can do Monday, 7th, Judge, if we want to do the PCC then.
And 11/27.
Yes, ma'am.
All right.
Judge, if I could,
Yeah.
you said bond is to continue, I just wanted to remind Ms. Somerville that that includes the no contact order. I know the victim is here currently, he's outside of the courtroom.
All right. You understand you can't have any contact with that person?
Well, Your
Do you
Honor,
understand?
Yes, ma'am.
Yes, Ms. Polkowitz?
Your Honor, I would ask for a no assaultive contact order modification instead of a no contact. I guess if the complainant's there, can we just ask what his preference would be?
Do you understand?
I did try to reach out to him, he didn't respond to me, but if he is here in person, I don't have any objection.
Well, we gotta bring him in. I have to hear him say that. Ma'am, you have a right to remain silent. I see you raising your hand. I just want you to understand your counsel's on Zoom. You can, but you have a right not to.
I don't know, it's just my daughter got pulled over, she had a warrant, she was supposed to drive me. The victim came and got me.
All right, Tammy.
So she just admitted to me that she violated the no contact order. All right, so Mr. Somerville, can you come on up? Mr. Somerville, they're requesting a bond modification between you and Miss Somerville. Did you drive her to court today?
Did you drive her to court today?
Yes, ma'am.
You know she's not allowed to be near you.
Well, if I hadn't went to where she is staying and had given her a ride to court, she wouldn't have any way to be here today, Your Honor.
Do you understand that she just violated the no contact provision by having you drive her to court?
Yes, I understand what you're saying. I was trying to help her out and to help her get through this, Your Honor.
Stop it.
Miss Pilkowitz, Miss Habner, here's the problem. Do you want contact with her?
You wanna come a little closer so you can.
Yeah, sir, why don't you come up? And can you tell me your first and last name? I need to know your first and last name.
Carlos Somerville.
Somerville? Mr. Somerville, they're requesting a bond modification. They're asking me to change Miss Somerville's bond so that she can be near you. Do you want that?
Well, Your Honor, she is living in New Boston with her friend or her boyfriend. I live in Taylor. If I could keep it that way, it would be fine with me.
Keep it what way? You picked her up for court today.
Yes, ma'am.
So listen to me. Listen to this question. Do you want to be able to talk to her? Yes or no?
Yes, I have to talk to her.
Okay, well,
We're getting a divorce.
so you want me to lift the order that says she can't talk to you?
Yes, if you would, please.
All right, but she's not allowed to assault you.
Right.
And that's what you want.
Beg your pardon.
Is that what you want?
Yeah, I want, see, I don't want her coming over to the house, causing trouble and wanting to take things out of the house and everything like that. But I don't want her to go to jail or anything.
Is that house the one on Mortonville?
Beg your pardon?
Is the house on Mortonville
Yes, ma'am.
or Morton View? I'm sorry.
Morton View.
All right, look, I'm gonna modify the bond because the complainant here, normally she'd go to jail right now. And I'm not so sure that she shouldn't, but
She
he
should.
went and picked her up to bring her to court today. It's her violation. She did what she wasn't supposed to, but he wants to have contact with her. So I'm gonna modify it to no assaultive contact, but she cannot go to the residence. Miss Somerville, can you see me?
No.
Stand up where you can see me. Do you understand what I am telling you?
Yes, ma'am.
You cannot go to the house over there.
Yes, Your Honor.
You shouldn't be finding him at all.
I know I'm not. He comes over and brings me cigarettes and money and stuff.
Well, he's awfully nice considering.
I've been with you for 33 and a half years.
All right. All right, Ms. Pilkowitz, November 27th at what time?
Judge, I can do,
PCC?
yeah, 8:30,
8:30?
8:30, 9, whatever the court, I can do anytime.
Let's just do 8:30 a.m. and that way we can do it first thing. You can come on Zoom. You don't have to come on person.
Your Honor, the phone, we were with AT&T and he has to release my SIM card for me to get my $1,600 iPhone to T-Mobile. So-
All right,
And
the Miss Somerville, listen, I'm not a family law judge. That sounds like that's something that'll be handled in your divorce. You're to be here. You have to come to court next Monday at 8:30 a.m. for your probable cause conference. And we'll set the exam date on that date, Miss Pilkowitz. All right?
Judge,
And
if we're
Mr.
setting-
Summer-
If we're setting the exam for that date, can we possibly do your latest time in the morning? I have to be in.
Well, no, we're doing a PCC
Oh,
at
to select
8:30
the
a.m.
exam.
And next week, on November 27th, we'll figure out the exam date at that time.
Understood.
All right. Bond continues with the modification. All right, we're all set.
Thank you, Judge. Tammy, you can give me a call later, okay?
thank you, Your Honor.
Yeah, the judge was not happy about that. Oh, man. And, everything about it was to benefit the assaulter, not the victim. And that's what the judge hated the most. The victim was having the condition lifted so that he could continue to bring her cigarettes and he could continue to give her rides when she needed. he's a victim that is still a victim that is allowing himself to be victimized. And that's the crappy thing. Yeah. I think she was talking to ex-wife Somerville when she said that. That was her. You don't have to come here. You don't have to have him drive you. You can just come by Zoom. But apparently not, because he hasn't released her phone yet. Again, another her problem. Like, oh, people like that just get under my skin. Oh, do 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 do. I love this guy's accent. And I can't think of what show or movie or whatever I have heard it before in. But I don't like the guy. I just like the accent. I like the voice.
Well, unless you need a break, Ms. Freeman.
No, I'm fine. Come on up, sir. Let me sit at this table.
Let me, you don't need to say anything right now, Mr. Villacana. I'm looking up something.
Have a seat.
Yeah, just have a seat.
Sir,
Just have
one of
a
these
seat.
tables. Over here? Yes.
Yeah. You take it easy there. I'm looking up a county code. So just hold your horses. Clallam County Code 1702. 1702. See if that shows up the way. There it is. Look at that. The wonders of the internet. Section 30.
My favorite judge.
Section 30. Following dog control regulations are designed to protect the public. Fine can be imposed without any regard to the intention of the violator. It is unlawful for the owner of a dog to prevent his animal from biting someone, or from running at large, or for not being under proper control on a person's property. You're also supposed to keep your dogs within an enclosed space while in heat, and they can't be chasing, running after, jumping at vehicles, or snapping or growling or barking at anybody. Mr. Villacana, I don't suppose you've ever read Clallam County Code 1702, Section 30, have you?
I did a little bit.
Right. I don't know what your opinion about that is, but it sounds like anytime your dog gets out of a yard or bites somebody, you're responsible, is how I read that. Do you read that a different way?
Yes.
How do you read it? How do you read it?
Well, my dogs, I had them tied up. It's a trail across my house, and people just go out there and they get them loose to walk with them up the trail. And so I put out shock collars, and they take them off too. I've been trying to have them under control. And they're not mean dogs. They're pretty friendly dogs. That's why they take them up to the trail. And they give them snacks and stuff. And all they do is just go across the road from my house to that trail.
Well, so here's the thing. And by the way, let's just, technically speaking, you're under oath now. So the testimony that you give the court is actually under oath. Do you swear to tell the court the truth today in response to these allegations, sir?
Yes.
Okay. And then, so what I've got is a ticket here, and it looks like somebody, this guy, Valen Hansen, got chewed up enough to, his clothes had some evidence of tearing from biting. A German Shepherd coming from the same area jumped onto him, and he had to knee it in the chest. So he had two different dogs biting at him. And he had pictures and video, which was reviewed by the officer. Now, did you actually see the police report?
No, they just, that ticket has been from, what, last year probably, the one you're talking about?
Yeah, right. So what this officer says, he says, I know the dogs from previous contacts and knew that they belonged to Fernando Villicana. I have witnessed the dog several times off the property. And the beagle-looking dog, the dog that did the first set of biting is the beagle-looking dog, has growled aggressively at the officer in the past. But then the officer says, however, on this particular day, on October 5th, when he went to the house, the dogs were friendly. And you had the German Shepherd in a crate. I don't know what the crate looks like. Is that normally how you keep the German Shepherd, is in a crate?
No, that's my daughter's dog. It was a little puppy. I don't think back then we had that dog though. I don't know what he's talking about.
Well, what's going on is the officer is just saying that he went up to your address and none of the dogs on that day bothered him. He didn't have a problem, is what he's saying. Okay. So what we've got is, we got a ticket where a guy, Balin Hansen, says he was chased and attacked by those dogs. The officer didn't see that. Nobody else saw that. Hang on. Let me finish that thought there. And then when the officer goes up to the property, the dogs are on the property and are no problem. You see what I'm saying?
Yes.
Okay. So I don't know if you want to say anything in addition. I actually believe this. I believe this witness's account that he got attacked by dogs, but there's no, I don't have any footage. I don't have any photographs or video that's spoken of in the report to know which dogs we're talking about. So I'm going to find that the infraction was not committed. I'm finding in your favor, but I'm not done with you yet. The way the ordinance reads, it doesn't matter if you think people are letting the dogs out. You're in charge of those dogs. It sounds like you got 4 or 5 dogs on that property. If they're biting people, that's your responsibility. And in fact, if this Balin Hansen wanted to sue you, he could sue you. Anybody that gets bitten by one of your dogs can sue you. So you need to be taking care of those dogs. I realize you're making some efforts, but when you say something to me like other people come by and let the dogs out, what that tells me is you're not taking care of your dogs. So, but based on the fact that I have an allegation that somebody got bitten or chased by 2 dogs, but I don't know from this recitation of facts that they were your dogs. And when the officer went up to the property, the dogs were contained and didn't bother him. So in other words, I'm not fighting for you because I think you're innocent. I'm fighting for you because I got contradictory evidence. I can't make a decision based on what I got. You see what I'm saying?
Yes.
Okay, but I don't want to see or hear from you again. I don't want law enforcement to tell me your dogs are biting somebody, because I just don't want to hear about that. I don't want that to happen. Can you try to take care of that for me?
Yeah, sure.
Okay. All right. That I found the infraction was not committed. My clerk will give you a copy of that. Melissa, are we done for the morning?
Miss Jessie has showed up, Your Honor.
Oh, good. Well, let's take care of Villicana and get him out of there, and then we'll take care of Jesse.
Okay.
I forgot about you. Thank you.
There you go.
Thank you very much.
Okay, Melissa, did you say that Miss Jessie's online?
Yes, Your Honor.
Okay, good. Can she hear me yet?
She needs to unmute herself first.
Miss Jessie, unmute
Here she
yourself.
goes.
Okay, here you go.
Okay.
Okay, hey, okay, so I'm glad you showed. Are you still living in Forks? You have a Forks address?
Yes.
Okay, so it wasn't too much trouble getting on Zoom today, was it?
Well, I was trying to figure it out, and that's why I was a little late. Sorry about that.
That's okay. I know you've talked to either my clerk or court administrator or both. I know you.
Yes, yes.
Yeah. So what is it you're trying to do right now? What is it you want to do with your license?
I just need a little more time. I'm in the process. I have to get my title changed over to my car and then get the interlock in. And if I could just get like another week or so.
Yeah, hang on a second. Melissa, we didn't find probable cause on this yet, did we?
No, Your Honor's first appearance.
Okay, hang on a second, Ms. Jessie.
Okay.
Don't go anywhere.
I'm not going anywhere.
Yeah, I know. I'm kidding you. When I say don't go running off, that's just my weird sense of humor. Okay, let's see here. But I don't want you to say anything right now because I'm reading I'm reading Chief Rowley's ticket. Yeah, he had reason to investigate erratic vehicle travel. So he made a stop on your vehicle. And I don't want you to answer that. I'm just looking for the reason for the stop. He made a stop based on a report of an erratically driven vehicle. And then it said that when he did the driver's check that you're currently suspended and you have to have an interlock. So I'm finding probable cause for the driving while license suspended. Also, interlock ignition device wasn't properly installed. So we're finding probable cause for that. Now, the maximum punishment on the interlock is 364 days in jail and a $5,000 fine. So if you're smart, and I assume you are, you're going to need an attorney to help you handle both of those charges. Are you going to hire an attorney?
Well, can I get one appointed?
Well, let's talk about your income. How are you putting food on the table right now?
I'm on Social Security.
Okay. So we're going to appoint Clallam Public Defenders to represent you. Okay.
Okay.
And we're going to set your arraignment out. My clerk's going to help me avoid holidays. How do you think the 27th is looking, Melissa?
Looks pretty good.
Okay, we're going to put you on for November 27th at 1:30 for what's called your arraignment, and we're appointing Clallam Public Defenders to represent you. Okay. So
okay.
It would be a good idea to call them. We'll get you that contact information, but their number's easy once you know it in Port Angeles. You tell them that they've been appointed to represent you. Make sure they have good contact information.
Okay.
Speaking of which, I just had are you
yeah.
What's a good telephone number for you? Okay. So make sure the Clallam Public Defenders knows that. We need to know that if we send you mail and you don't get it, or you don't respond to it, we have to issue a warrant for you. We don't want to do that. But we're going to see you Monday, the 27th at 1:30. Make sure you call your attorney before then. You can't be, you probably know you're living in Forks, don't you?
Yeah, I do.
Everybody and his kid brother is going to know that you're not supposed to be driving. So you know what that means.
Yes, I do.
Yeah, Rowley's going to have to arrest you if somebody sees you driving around town again without that interlock or good license. He's going to put you in jail.
Right.
Okay. All right. We'll see you Monday the 27th. Okay.
Okay.
Thank you.
Thank you.
Melissa, how are we doing now?
We are done, Your Honor.
Thank you, ma'am. I'm going to get off. I'll talk to you later. All right.
Okay, bye-bye.
If I can get off.
Chidaskedum, you heard your stomping grounds, and that's why you came. This woman just seems a bit lost to me. Like nothing else happens but this. But just her demeanor, her state, she just seems lost. But yeah, you can tell he did not like having to dismiss the irresponsible dog guy. And if anybody can remind me what show or movie I have heard that accent from, I'd appreciate it. Um, but yeah, don't you hate it when other people all the time just come up to your property? They take your dog's shot collars off of them and untie them from their leashes, only to take them for walks on the trail across from your house. You know, golly, people do that to me all the time. To my barking, snarling dogs, you know. Oh my goodness. Oh. Oh, today's the 21st. Okay, and she's not in the chat, so I'm safe to do this. All right, y'all. Today is Dolphin's birthday. So if you see her in any other court channels today, if she happens to pop in, you know, during class or something, make sure you wish her a happy birthday. I'd saved it in my calendar when she had mentioned it one day. And that's today. So make sure to wish Dolphins a very happy birthday. I have not watched it yet, but I have it. I don't have it edited. But I do have it. Not where I'm at. It is now the 21st. It is 1 a.m. where I am. So it is now the 21st. So it will be the 21st when she wakes up to go to school. I love her. I love all you guys. And I'll always try to make it a point. Well, you get to be special. You can see the future. I don't know. Why don't you look at your phone clock? What does it say? Yes. Happy birthday to Dolphins. Is it the winter solstice? The longest day of the year? Or shortest day of the year? Shortest day of the year? Is that how that goes? I get them confused. You are Philip Heels. You are very special. Yeah, it's the shortest. Yeah. Yeah, Dolphins is loved. Well, hi. All right, let me see. Let me see what I got. I've got to take some of this stuff out of my stuff that I have played. Because, you know, some of it I have played. And some of it I don't remember if I played or not. But, here we go. Stop driving or setting a stripper straight. We'll start with stop driving and then we'll go to setting a stripper straight.
Record in the matter of the state of Michigan versus Keith Long, 232293.
Second, Your Honor, John Gold, 4P 30758 on behalf of Keith Long, along with the name on the record.
Keith, that is wrong. All right, thank you. And today's date scheduled, I hate this chair, for arraignment pretrial in council.
Your Honor, first of all, Mr. Long apologizes for not being here at 9 o'clock. When he posted his bond, he was informed that it was at 1 o'clock.
Who told him that?
When I had called, the woman told me 1 o'clock.
When you called where?
The courthouse, and they gave me a piece of paper and circled the number for me to call. When I called that number, the woman told me 1 o'clock on the 16th.
Hold on, what paper did you have?
I
have it
don't
with
know,
you?
bond, I can't, no, I don't. It was a piece of paper, when they gave me the personal bond, they gave me that paper. He was like, call this number to schedule your court date. That's exactly what I did, so when I called, he said 1 o'clock. What's crazy is I was on the phone with my federal probation officer and told him the same thing, that it's at 1 o'clock on the 16th.
Regardless, Your Honor, he did show up at 1 o'clock today, but
Yeah, I deeply apologize.
I know, I'm just trying to figure out what document had you calling, and anyway, that's okay. All right.
I just want to bring that to the court's attention. He got here at the time he thought he was going to go to here.
Okay.
Your Honor, as to the arraignment, he would stand new to the charge, waive a formal reading of those charges, and ask for a plea of not guilty.
All right, the court's going to waive the formal reading, enter plea of not guilty for purposes of the arraignment as to the pretrial.
Your Honor, at this point in time, Mr. Long would plead as charged, driving while license suspended.
All right, sir, please raise your right hand. Do you solemnly swear from the testimony about to give this time to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, and you heard the plea that your attorney placed on the record, correct?
Yes, ma'am.
And as to the charge of driving while license suspended, how do you plead?
I plead guilty, Your Honor.
And you found over your rights with your attorney, correct?
Yes, ma'am.
And in fact, you signed that document.
Yeah.
And you also understand all of those rights.
Yes, ma'am.
You understand by entering into a plea that you'll be waiving some of those rights, specifically your trial and appellate rights.
Yes, ma'am.
And you also understand the possible penalty as a result of your plea, whether in this court or any other court or administrative agency. And knowing all that, you still want to continue with your plea.
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, counsel, if you can please order your client.
Thank you. Mr. Long, back on the 26th of October, were you operating a motor vehicle in the city of Wyandotte?
Yes.
And did there come a point in time when you came in contact with the Wyandotte Police Department?
Yes.
And when they asked you to provide you with a driver's license, were you able to do so?
No.
And your license is suspended, is that correct?
Correct.
And your offense is satisfied, right? And you
All
did
right.
that, correct?
Yeah.
All right, the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the count one and as to sentencing counsel.
Your Honor, this was an incident which occurred a couple of weeks ago. Mr. Long has just signed federal parole out of the matter, and he's been out of prison, federal prison, for about the last 8 months. Your Honor, prior to that, he caught a lot of driving unsuspended. They were basically reinstatement fees, is that correct? And driver responsibility fees at that time. He is now out. He has made, obviously his parole officer is well aware of all of the circumstances. Part of that is that he is trying to take steps to get all of his license set aside. This was an isolated incident. He knew he wasn't supposed to be driving. He's on a federal curfew. His significant other, who is out in the parking lot today, went to pick him up. Is that correct?
Yes.
She became ill, and he made a determination that he had to get home to get to the curfew, made that mistake, and that's the reason.
She suddenly became ill after she picked you up.
She said she wasn't feeling well, and she had vomited in the, in the car and whatnot, so. I made a bad decision, Your Honor. I thought it was down, so I shouldn't have been driving, period. She was picked the phone up and continued to try to call. That's the bottom line.
Where was she supposedly picking you up from?
Why not on, I can't remember the name of the street, but I was coming from, 2nd Street. A friend of mine, but they do not drive.
Your phone should be off. I believe there are signs out there that say phones should be off.
The judge does not believe him. Not even a little bit.
Not yet.
I just put it on, do not disturb, Your Honor. Come on.
Sir, okay, listen, this is going to be your opportunity to stay out of jail. So you need to level with me. Do not lie to me about why you were driving.
That's really why I was driving, Your Honor.
Really?
Swear to God.
So the two of you were door dashing?
Well, that's what we were actually doing, yeah.
That's not what you just said.
No,
What you said is she was picking you up from a friend,
She was.
and then she got
Prior to
sick,
that, we
and
was door
stop
dashing.
interrupting me. Prior to that, she got sick, and then you decided to drive.
That's correct.
You didn't say one thing about door dashing.
That was prior to the incident. Other than that, I have a curfew, I had to get home. Okay, so the door dashing was pretty much over with. She was door dashing on her own, I was at a friend of mine. Okay, when she had came back to pick me up, she said she wasn't feeling well. And she actually vomited in the car. Okay, my curfew is 11 o'clock, I needed to get back to the house as soon as possible. Yeah, the door dashing was previous before that.
Well, the claims that, it says that, both you and your passenger explained you were just out door dashing. Didn't say anything about being picked up from a friend's house or anything like that.
That's what we were out doing. That's what the remark was.
And this was already after 11 o'clock, sir.
I was running late, Your Honor. That's why I was like pressed to get home. That's why I was like, I'm not here. Look, I'll drive. Yeah.
You were already 23 minutes late from your curfew.
That is correct.
And Your Honor, he has spoken to his probation officer, parole officer regarding this matter. And in fact, there was a parole officer who helped him obtain his release. Is that correct?
Yeah.
What do you want federal probation for?
Felon in possession of firearms. I got
Nope.
indicted for weapons being inside of a home and criminal history. I got charged with their firearms.
Well, typically firearms aren't charged federally, so what else was going on with that?
Your Honor, if I may, and I wasn't part of this, but I've had a number of clients. Sometimes they take them on a federal firearm, sometimes they don't, but I've had 3 in the last year.
Most weapons charges nowadays, they're gonna be federally indicted for weapons. It's not gonna be a state charge anymore.
And so, what kind of car do you have, sir?
I don't have a car at all. Because Ford Focus.
And what color is it?
Red.
And that car is out in the parking lot?
Yes, ma'am.
And she's in the parking lot?
Yes, ma'am.
All right, we're going to confirm that. What we call the standard. Okay, so we are going back on the record in the matter of Keith Long. Okay, so it was confirmed that the red Focus is out there and your girlfriend is in the driver's seat. So where do you work, sir?
I do on-site work as a contractor, boarding up abandoned houses in downtown Detroit.
DoorDash.
How do you get back and forth to work?
A friend of mine, Cliff, takes me and It's his construction.
Oh, sorry, honey. I feel that.
For order, $500 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, $825.
I believe there's a $500 bond. Your Honor.
I don't think so.
Maybe the personal one, I'm sorry. Your Honor,
Billy
yeah,
O.T.
Today, you need some time. And thanks for it.
The best kitty ever, Billy O.T.
You're ready to pay today.
No, I gotta pay tomorrow. I come up here tomorrow, make a payment.
Okay, so if you can make a payment tomorrow and over the last month, you've received a couple of paychecks, right?
That's about it, yeah.
Okay, but you didn't set anything aside for your court date today?
I didn't know that I was gonna, come to town. No. I mean, I have a little bit of money, but not enough to make a payment. That's like, I'm trying to make like at least $50, on a payment.
All right, can you pay $50 a month?
Yes, ma'am.
You can bring the payment in tomorrow, so we'll say beginning November 17th and the 17th of every month.
Yes, ma'am.
Sir, stop driving, seriously. It may seem minuscule, it may seem, not a big deal, but there's a lot of collateral consequences when that happens. And really, it just shows that you have zero regard for the law. It really does.
I got you. I apologize.
Lots of people get me today, but they don't seem to,
No, I understand.
We're working through these.
Correct.
yeah.
Your Honor, thank you.
I knew it, here we go. Told you, off the record, but at least your case is done.
Thank you.
Have a good
Thank you, Your Honor.
I have a good Thanksgiving. I knew it.
Back it up, Billy.
Pay you up early if you can, sir. Get it, and get your license back.
I got, thank you.
You're lucky. I just wasn't off the record, but at least your case is done.
That's right. All right.
What is a gum leaf? And why should I get it for Billy O.T.? I've never heard of that. Oh no. Well, they can see ghosts. Oh, I would be mad. Kova girl. Honey, you gotta be very careful how you phrase things in my chat. That is not a good way to phrase that. It will be taken wrong. And everyone will laugh. Billy O.T. is now comfortably resting his head on the number pad. So if y'all see some numbers typed, it is not my phone number. Perhaps Billy O.T. has a secret cell phone that he's gonna try to give y'all the number for. This is my absolute baby. This is my love of my life. He is the most perfect kitty cat. I have not been touching that mute button very much at all tonight. And it's not going to happen. No, I don't want to. I don't want to do it. Man, that was, see, it gives me an initial warning that says mic is mute, or muted, something like that. But it's just, it just flashes it on the screen real quick and then it goes away. It figures, well, she must know. Nope. I usually don't know. I usually am on a rant. And I'm not looking at chat, and I'm not looking at the screen that says mic is muted. I'm looking at my camera and ranting. Oh. Well, see, a billy is a bucket. So in back in the time of sea shanty days, a billy was a bucket. So a billy o' tea is a bucket of tea. So it's being steeped in the bucket, not in a gum leaf. Oh, I agree. 100%. But I'm just saying it needs to be phrased or it will be taken another way. Both kinds are good. No, thanks, Philip. What a pal. I've never experienced it. I'm sorry. I've never experienced it. I've never had a gum leaf. I don't even know what a gum leaf looks like. You're welcome to mail me a gum leaf. Anybody overseas is welcome to mail me anything. Anything from your country. Absolutely, I would love it. Oh, honey, that's terrible. I'm glad it's not terrible that you're feeling better, that we're making you happier, but it's terrible that you've had COVID. Oh my gosh. I'm happy to be a good distraction. I had the worst tummy ache yesterday. That's why I wasn't on. And it's today, but I'm well enough to be here, and hopefully that's making somebody feel better. If it's you, then mission accomplished, and I'm happy about it. CE, you are usually the cause of my muted rantings. You ask questions that I feel compelled to answer, and then I'll quick hit the button and go on my little rant. But not today, CE. You will not get me today. But what does the gum leaf do? I guess that's what I'm confused about. Everybody always comments about my laugh, and I've never thought it was anything special. It's just me. Yes, absolutely. We want you better. We want you happy. We want you laughing, but probably not at the moment because that might hurt. Because I remember that. Oh, so eucalyptus comes from gum leaves? I didn't know that. I've been trying to put it up on the screen. I don't know. Philip he was saying that I had to, when I make tea, he was referencing Billy O.T., my kitty cat that I was giving loves to. He was saying that I had to put a gum leaf in the tea. And I was really confused because I had no idea what he was talking about. And apparently eucalyptus oil comes from the gum leaf and is seeped into the tea. And I am just saying that anybody from Australia, England, I know I've got New Zealand. If y'all want to send me, something that won't get us in trouble at customs, that is, reminiscent of your home country, like, like a gum tree leaf. Oh, yeah, no. That would get us in trouble. And we can grow that in the United States. Yes. No. All right, let me see what else I got. I know I'm like not lined up in my camera square anymore, but I can't move my laptop anymore because it's now a bed for a very spoiled kitty cat. Yep. He is a very spoiled. All right. Oh, I said I was going to run setting up stripper straight. And then there's no Mexico after that.
All right, so we are on the record in the matter of City of Wyandotte versus Angela Vargo, 222047 B and 232257. Okay, sorry. Council, your appearance, please.
Thank you, Your Honor. Your Honor, John Goldclough, P 30758 on behalf of Ms. Vargo on both ends.
All right, and your name, please. All right, thank you. Today's date scheduled for sentencing on your client's plea on the possession of controlled substance on 222047B and on the sale of the display on the 222257A. So let's see, the other one was the failed display, but since it was, since she was being sentenced on this one, we kept them together, but the other one is, the court's going to got the recommendation of fines and costs only on that one. So let's just handle the sentencing, the report and recommendation on 222047.
Thank you very much. I have had an opportunity to review the pre-sentence report with Ms. Vargo on this particular matter. There is no, there are no additions, deletions, or corrections to be made with respect to this, correct? We have gone over that. She is full-time employment. She is addressing the issues that were presented at this point in time. So with that said, Your Honor, I note that she does have some outstanding warrants. She has been taking care of those. She has been contacting the different courts. She's learned what she has to do, how much money she has to show up with, for lack of a better term, and she anticipates that those will be taken care of within the next 2 or 3 weeks. Is that correct? Our discussions that we are gathering the money and taking stage. She did write them all down when she was informed of. Other than that, Your Honor, I see that she's also eligible for early termination, and we are asking that the recommendation be adopted. This is to be taken under the city ordinance of 25.136.
All right, I have a couple questions.
Yes, sir.
Your weekly income is $1,000 a week.
Well, it was when I was dancing at that club I was working at prior to getting arrested, but I've decided I'm not gonna work there anymore after getting out of jail, because I just don't wanna be in that environment, you know, considering the alcohol tether and other things. So now I've dropped down to about like 400 or 500 a week with my painting job.
Well, hold on. This shows that it says you're employed as a painter, full-time and part-time at the club.
Yeah,
So, okay, so you're not part-time at the club anymore. Now you're full-time as a painter.
yes,
And so your weekly income was $1,000. Now you're saying it's more like $400 or $500?
yes. The added income was with the days I worked at the club.
Okay, and so even at your weekly income of $1,000, let's just say that, you were still receiving $450 on a bridge card? At $52,000 a year, you were still receiving that much money from state assistance.
Well, I just kind of guessed how much I was making. I don't think it was really that much. I don't know. It would vary from week to week. On like the days I worked. Plus the club got really slow.
Okay, do you have a valid medical marijuana card?
No.
Okay. When's the last time you used marijuana?
The day I went to jail, prior to going to jail, that's the last time.
And do you have a prescription for oxycodone?
No, I do not.
When's the last time you used oxycodone?
Also the day I was arrested.
All right, counsel.
Your Honor, indicated, she would ask that this matter be taken under advisement, for lack of a better term, under the city ordinance. She understands the circumstances, she understands her responsibilities in this matter, she understands the responsibilities that she has with her 8-year-old daughter. She has to be a good example for her. Her 8-year-old daughter lives with the child's father. She sees the young lady on weekends, as indicated here. She is taking care of her problems. She's addressing those. She's continuing employment, and we're asking that the recommendation be adopted.
And so why does your daughter live with her father?
Well, this is the first time she ever has in the whole year, because she's 8 years old. He was actually helping me so I could work during the week, and he was taking her to school for me this year, just for this year. I was planning on getting her back probably before the end of the school year, full time. But now I'm kind of held back with more court fees rather than finding a new place, but that's fine. I want to get this stuff taken care of and move on to a better life.
Hard to strip with a tether.
All right. What seems to be missing from the criminal history though is the OWI that you have out of, I think, at the Allen Park. Isn't that what one of your awards is for, because you have a probation violation for that?
I actually went to court for Allen Park, like, I think I just had a PSI for them yesterday, and I have court for them on December something. I can check on my notebook I have at home.
Oh, I'm sorry. Okay, and what about the 43rd District Court in Ferndale?
That one, I have to get up 1100 in order to get a new court date, or else I'll be like incarcerated, and that really won't help, you know, being in jail rather than being able to pay all my fees and get the stuff taken care of.
You can get that in one night.
I'm gonna
In
fix it
ones.
as possible, right? All my money I'm working for right now is all going towards court costs. I'm not spending it on anything else.
Which I'm sure is very annoying, but at the end of all that.
It'll be worth it.
All right, anything else, counsel?
No, Your Honor.
All right. So the court will state that Ms. Vargo that there is reasonable grounds to depart from MCL 769.5 after hearing from counsel, hearing from Ms. Vargo, reviewing the report, the recommendation. The report calls for 12 months probation. I think Ms. Vargo would benefit from 18 months probation. You are eligible for early discharge. The matter will also be taken under 25.136B. You're not to violate any criminal law or union of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're notifying your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining absence and sobriety. You are to enroll and participate in outpatient substance use counseling or intensive outpatient, depending on what the screening determines that you need. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so you may maintain sobriety and prevent relapse. The court's going to also order you to participate in the fan meetings once per month. The first meeting is tomorrow. Make sure you're there. The rehabilitative goal for that condition is so that you can have a support system, an additional support system, I should say, as well as obtaining recovery resources. The court's going to also order you to clear up your warrants, and you are to perform 80 hours of community service. The rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community.
Yes, Your Honor.
Any questions regarding your terms and conditions?
No.
All right, as to the fines and costs, the court's going to order a $400 fine, $100 screening assessment fee, supervision oversight fee of $900. That's $50 a month at 18 months. Since you're eligible for early discharge, some of that money may not be due. $3 for cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. And there's a warrant fee of $50, a clearance fee of $45. $18.20. Are we keeping you up, sir? I'm sorry that we're taking so long. Okay, so that's as to this matter, and then on the other matter of the 2-3.
Was the warrant fee on this case or?
Yes, because this matter was from 22.
Okay, just wanted to keep things straight, Your Honor. Thank you.
Yes.
So what was that total?
18.20.
Thank you.
Plus, I know that the other matter was dismissed, but there's also a warrant fee from count A. As well, and so then that's actually 1870. And on the sales and display, which is the 23 matter, the court's going to order fines and costs only. It's a $100 fine, $200 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of screening fee, so $525. And so what is your, well, let's see, you have a $500 bond on the 23 matter. So do you have $25 to pay on that matter?
Today?
Yes.
Yes.
Okay, so I will indicate that's payable today. Okay, and then on the 1870, you do have a $500 bond that we can apply. Do you have any other funds to pay today, ma'am?
I do not. I think I have $45 total.
25 is coming to the.
Yeah.
No, I understand.
Yeah, I understand.
So $500 today, that'll be your bond that's applied. Add to the balance of $1,370, how much can you pay per month and what day of the month works best?
You pay $100 a month
Yeah, 100.
and you always pay more. You understand that?
Yes.
And you want to get this paid off as quickly as possible so we can eliminate about $450 of commission.
Or a can of
Right, so $50 per
WD-40.
month.
100.
Oh, $100, I'm sorry, I thought I heard you say 50.
Well, if we could do 50.
Did you get it all paid off?
Yeah.
150?
No, just 50.
50.
Yeah.
Yeah.
And what day of the month?
Well, something.
Please, best.
I'll do the 6th.
Beginning December 6th?
Yeah.
both the Santos chair and the saloon style door for the witness box, which the bailiff goes in and out of that door a few times. That's what makes that creaking sound is the saloon style door. So they need a WD-40 DeSantos chair and the hinges for the witness box door.
All right. All right, so $50 a month beginning December 6th. All right, as I did indicate, you are eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've completed at least half of your original term of probation. Oh, wait, I think I just said that, yes. You have had at least 3 months without any violations, and all money has been either paid in full or you've made a good faith effort to make the full payment. Okay? All right, so let's give Language Line a call.
Okay.
All right, we're going to go off the record for a moment.
It was not mine. Mine does make noises, but I would show you, but I'm suffering from feline paralysis at the moment. I am pinned down. Maybe it's possible. Yes. Yes, that's the ink stamper I was talking about. Oh my goodness. Yeah, you get the general idea though. And the only reason that I'm able to participate right now is because of the mouse that Becky D got me. Because I'm currently, I've lost the use of one arm completely. Yeah. Yeah, it is great. It's the only condition that I approve of having. Oh my gosh. Just a little DeSanto gift box. Everybody in the internet would know exactly why she received the items that she got, but she would be confused. Yes, it is. Oh, okay. Well then. He has seen something on the dresser that he has decided it is now time to knock off. That is. He missed his mark by that much. And so his front paws made it to the dresser, but he just kind of hung there. Because his back paws didn't quite get up over. Oh, that was funny. I have cat fur all over my face. And it's tickling my nose. Oh, good night, April and Tink. Sleep sweet. We love you. Yeah. He was. Mm-hmm. Well, that's because most of the time the cats are bigger than your palms. Oh. Okay, I'm putting the next clip on and then I gotta go blow my nose because I have cat fur in my nose. Hi,
On
love.
the record, in the matter of the city of Riverview versus Jacob Zeden, 232213.
Chief Serrano, P33828. I appear as MIDC counsel on behalf of with my client. This being the date and time set for arraignment pre-trial. Please state your name for the record, sir.
Jacob Ziden.
All right, thank you. And good afternoon. I do apologize for your wait today, sir. And counsel, as to the arraignment.
Your Honor, as to the arraignment, I've explained my client, this is the nature of the charges against him, all the maximum penalties, either from this court or any other administrative agency understands them, as well as all of his constitutional rights. Thereby, we wait for a reading stand mute today.
Court waive the formal reading, enter plea of not guilty for purposes of the arraignment, and as to the pretrial counsel.
Your Honor, I have had significant negotiations with the prosecutor. We are making progress. We're confident this matter is going to be resolved, but we're both asking for an adjournment because no blood work has been sent to the file yet. So we cannot examine that aspect. So we'd ask for a short adjournment. Your Honor, I told the prosecutor if he comes back sooner, we can come in sooner. But he's put 30 days, so I think it's the court's discretion.
Well, you're here on the 13th, counsel, so let's do that.
That's
in
fine.
4 weeks.
That's fine, Your Honor.
So December 13th at 10 a.m.
I understand you have to be here in person again, right, sir?
Yeah, but actually I might not be here in Michigan till like the 17th.
Where are you going to be?
I'm going to be in Mexico.
Well, we have to ask the court's permission for you to leave to go to Mexico, so you tell me about that.
What are you supposed to be in Mexico for, sir?
Family trip.
Well, I don't know if that's going to be a thing anymore because you're going to be on bond in this court. So.
Have you, may I, Your Honor?
You may.
Have you already paid for that trip and made commitments?
Yeah, I made,
Is that yes?
yeah.
When did you make those arrangements, sir?
About almost 2 months ago.
And counsel, I guess we'll go into bond right now.
Pardon me, Your Honor?
We'll go into the issue of bond right now.
Well, Your Honor, my client's not on probation or parole, there's nothing pending. He's working full-time, correct, sir? And, Your Honor, I apologize, I did not know about his leaving the country, but I think that he's not trying to evade the process by this court. I think the court could
Sweet.
accommodate him.
Feel better.
Maybe returning in a week after he returns. What is your return date, sir?
Around the 15th.
Of what?
Like Sunday.
Around the 15th? I mean, how long are you going to Mexico?
Because it could be sooner, it could be like the 13th or 14th. But we're going to majority just for a week, we're driving.
I'm quite confused.
I'm driving from the 7th and we're staying, and it depends what time we get back, but it's gonna be before 17th for sure.
So what have you already paid for?
We're staying
Which is where?
a hotel in Muscle
And who are you going with?
a few of my friends, and we're gonna meet my parents there.
Well, counsel, I see red flags all over the place.
Mr. Ziden, you understand that this being an alcohol offense, the court is more than likely going to tell you that you cannot consume any alcohol or any unprescribed medications. Do you agree to that?
Yes.
What's the matter in Washtenaw County?
You have something pending in Washtenaw County that you didn't tell me about.
Situation that I'm not sure how long ago.
Well, it was about a week before this matter. So what does that matter?
Around the same situation.
What were you charged with, sir?
I'm not sure. They didn't really tell me what my charges were.
Okay, well, were you arrested for alcohol related drinking?
Yes.
Okay, well, I'm going to ixnay your Mexico trip, sir. You have 2 drinking and driving offenses within 1 week of each other. And you want to go to Mexico driving with your friends.
Yeah, but I'm not driving. I wouldn't be driving.
Sir, I have some concerns with whatever path you're on right now, because you have 2 alcohol-related offenses within 1 week. So hopefully you can get the money back on your hotel. I mean, it's a month ahead of time, so you should be able to get that.
Are we off the record then, Ron?
I don't know, I think she's stuck. I don't think we can be off the record right now.
Your Honor, may I approach? May I approach?
On this matter?
Well, I can wait till we're back on the record, Your Honor.
Okay, well, I mean, we're still on the record. We haven't gone off the record.
All right, well, I just wanted to ask if the court would consider perhaps a tether of some type. It doesn't have to miss this trip.
No, I'm not. No, this is, no, I won't, I was considering that until I looked in his criminal history and saw what, occurred a week before this. You haven't had a court date in that case yet, sir?
No. Your Honor, I was unaware of that other matter.
I understand. Do you have any other matters since this date?
No.
It appears though there was an accident in this case.
There was a one vehicle accident, his vehicle, is that correct, Mr. Ziden?
Yes.
Well, I guess you're fortunate you didn't go into the creek. Do you want me to go off the record? Can we go off the record? Okay, we'll go off the record. I didn't.
May we have a seat for a moment, Your Honor?
Yes. We are recalling the matter of Jacob Ziden, 232213.
Ready? Your Honor, once again, we're to P. Serrano, P333828, appearing on behalf of with Mr. Ziden.
Yeah, sir, your name again, please.
Jacob Ziden.
Okay, and so we had to go off the record because we were having a technical malfunction. And so the court was at the point where it was not going to permit Mr. Ziden to travel to Mexico, given the two of the exact same charges within a week in two different jurisdictions. And counsel, anything else as it relates to bond?
Nothing further, Your Honor. We were still on the record when I requested a tether, but that was the, other than that, Your Honor, no.
Well, your request was for Mr. Ziden to have permission to travel while having a tether.
Correct.
Right, okay. And what the court's going to order is the court will continue your $5,000 personal bond, not to possess and consuming alcohol or drugs unless prescribed. I'm going to order you to participate in random testing. The court has some concerns, some serious concerns for the safety of the public, given the charges that are 1 week apart in two different jurisdictions. And the court will also reiterate that your defendant does not have permission to travel.
So the original court date, December 13th, is still in place?
No, it's December 20. Oh, yes, December 13th, yes.
Okay.
All right, sir, please have a seat over in probation and they will get you the information regarding testing, okay?
Thank you, Your Honor.
Thank you. Have a good day. All right.
Yep. So she ex-nayed the Mexico trip. Red flags all over the place. Because I imagine it would have been red flags and tequila shots and possibly a worm or two. Yeah, she's got a pretty good intuition when it comes to people. So I trust that she knows what the heck she's thinking. Let's see here. I know we've done quite a few of these. Oh, did I do this one yet? I might have done this one.
Haygood and Candace Harper. Okay, and Mr. Haygood is position number 8.
Sorry, that was the guy that was in bed. That's what I said. I gotta clear out my not streamed folder because a lot of it's been streamed.
17, Anthony Darnell Stroud and Walteria Jordan. Okay, Mr. Stroud, if you could go ahead and turn on your camera, turn off your mute, and both of you raise your right hands, please. Okay. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
Yes.
Okay. So I am showing that we have received no payments, Mr. Stroud. And I know I've spoken to you before, so tell me what is going on.
I just been looking for new employment.
Do you have employment right now?
I'm gonna have an interview coming up on the 19th.
Mr. Stroud, you need to know that your driver's license was suspended on 10/29.
You said they were suspended?
Yes.
Mm-hmm.
Okay, and what do I have to go about to get them reinstated?
You need to go into the office. Mm-hmm.
I'm sorry, I couldn't hear you.
You need to go into the office, the child support office. They're going to tell you how much money you are going to have to pay to get it reinstated. So now you have escalated your situation, because rather than just having to pay the $400, you're going to have to pay a purge amount, which is more than likely going to be more than the $400. So that's what happens when you don't take care of things in an expedient way. Okay, so I am going to reset for January the 5th to make sure that you do go into the office and find out what you need to do. And that way, when you come back, you can, let Miss Jordan know basically what the purge amount is, so that she'll know that she's going to expect some money.
Also, Mr. Stroud, looks like they sent you an invitation to the fatherhood program. Did you receive that?
No, I haven't received it through the mail.
Yeah, make sure we've got the correct address for you. I'm going to send you a chat, make sure it's correct.
Okay.
And just to let you know, Mr. Stroud, because people do this all the time, they don't pay attention to things, and things keep escalating, and they could find themselves then in a very, very bad, they start out in a bad situation, but you end up in a very, very, very bad situation. If you're driving and your license has been suspended, then there's going to be more fines, more issues that are going to occur because of that. And none of this is going to go away until you begin taking care of these responsibilities. So I just want to make sure you understand that, because a lot of times people come in and they explain all of these issues that have led to their bad luck, but it's not really bad luck. You're in control. You need to pay your child support. You need to go into that office. You need to see what needs to be done so that you can get your driver's license restored. If you ignore it, I can pretty much guarantee things are just going to go downhill. Okay?
All right.
Miss Jordan, are you okay?
Yes, I'm fine.
Okay, we're working on it. We'll try to see what we can do to get things back on track.
I'm sorry. Mr. Stroud, did you get my chat with the address that we have? I want you to confirm whether that's correct or not.
Yes, it's correct.
Thank you.
Okay, I'm going to dismiss you until January the 5th, 2024. Okay?
So we
both come
back at that date?
Yeah, because I'm not certain where Mr. Stroud is with things. We might have to do an arrest warrant, so I would need you to know that you have to come in and sign.
Okay.
Okay?
Mr. Stroud, when you go in the office, ask them about that fatherhood, because they sent you the letter, and if you didn't get it, it's kind of important. That's job opportunities.
They have matching here.
Okay.
Okay.
And you said she had to file a arrest warrant?
I'm not telling, no, that would be on January the 5th.
Okay.
Okay, but I have not issued it yet. right now, all you have is a reset for January the 5th of 2024. But on that date, I'm going to follow up to make sure that you have been into the office and found out what you need to do to get your driver's license. You need to follow up with the fatherhood program. I'm not trying to put you in jail. I want you to start moving forward and doing things that are going to prevent you from having to be in jail. Okay?
Okay.
Okay, good luck and have a Merry Christmas.
Thank you. Same to you.
You're welcome. Malcolm Maddox and Sierra Swain. Okay, could both of my parties put your faces in view, turn on your cameras, and raise your right hands, please? Mr. Maddox, can you turn on your camera and turn off your mute?
I think he's about to come back to the screen.
There we go.
Okay. I'm pulling over right now.
Okay, yeah, drive safely. Just pull over before we do anything. Okay, if you could raise your right hands, please. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
Okay. Okay. So, I am showing that the last payment received was in September, but Mr. Maddox, you appear to be working a job. Why is it that we're not seeing child support?
Yes, ma'am. Just like I explained last time, it just having my kids, and I've had them, majority since we saw last time. But just having them every Monday, Wednesday, and every other weekend. I haven't been. I've been providing for them in my own home.
Okay, I'm gonna stop you right there, Mr. Maddox, because
no, I'm just.
okay, you can unmute him, but
Yes, ma'am. But to just nip everything in the bud, I was just asking, can I have the income deduction order so that I can turn it into my job and move forward and be done with this whole thing?
of course you can. Have you asked for one? Because we usually ask you.
No, ma'am, I haven't. And I didn't ask for one last time. So can I get one now, and I will turn that in?
And when are you, now you understand too, that that's not going to be an excuse because you have to make payments until that goes into place. So tell me when you are going to make your payment of $381.
Next Friday. This is the first weekend that I haven't had my children, and I'm able to work.
But I don't want to even hear about that. You're working right now. I mean, if you need to have the children less so that you can support them, that I'm sure can be arranged, but this can't be the reason that you're not paying child support.
It actually is 100%. But like I said, I will, like I said, if the money is all that matters to you guys and not my children, so I will just pay the money.
Well, of course, the children matter. That's why we're asking for the money. So, can someone give him the income deduction in the chat so that we can get things started?
John, all I need to know is his job. I'm going to try to send him a chat here, and then just send me back your job information.
All right.
So he has kids Monday and Wednesday,
I just
2
sent
days
you
a week.
a little message. If you
And
type
every
back
other
your
weekend.
job information, we have job information, and we sent out a deduction in July, it looks like, but we didn't get anything back.
Yeah, I
Are
never
you,
received it.
It
oh,
may
are
be a
you
different job. It
self-employed?
goes
Huh?
Are you
it goes to your
self-employed or
job.
do you have an employer?
I have an employer.
Okay. Yeah, it wouldn't, you wouldn't receive it. It would go to your employer, the address that you gave us.
Okay. Yeah. They like I've already spoken with them and they're on board, but they just had with moving forward with it and getting everything taken care of. So the moment they get it, it'll be signed and taken care of. But
Well,
yeah,
not, it's gonna take, it's gonna take a few weeks, so that's why I'm telling you, you need to make your child support payments directly, you know, until you start actually seeing the money come out of your paycheck. Okay, so you make it directly into child support.
Trying to find the job that he said. He just gave me an address. Okay. Okay, I think we have something here that I can, yeah, all right, I found it, and I will have them send something over to that job. We had a different job.
Okay, and I am gonna reset you for January the 19th so that we can make sure that we have the paperwork that we need and that it's moving forward. And also you need to, you know, go ahead and get your payment in for December because you're already at $1,924 in arrearages for non-payment of child support. And we don't want that to continue growing. So just make sure that you, you know, start paying into child support so that we have record of what is being paid. Okay, any questions?
I have a question, Tanner. Could you reiterate what you mentioned in the introduction about the past due child support? I know when we came to court last month, there was an order for him to pay November and December before today's date.
Right. And unfortunately, once it actually falls into arrearage and it gets put into that amount of arrearage, you know, I can't order him to pay it because then he would be paying it twice, you know, but so he's got $1,924 in arrearage. That would not count December as yet. So that's why I want December to just go ahead and pay that so that we don't continue to make that amount larger. Okay?
so I'm gonna pay that by Friday. But Your Honor, may I be excused? I have a cardiologist appointment I'm about to walk into.
Okay, we are done. Just make sure that you're here January the 19th and make sure that you pay that 381 during the month of December. Okay?
Gotcha. Okay.
Another question, I asked last time if I had to be present, but I still received a letter in the mail to be present for today.
Mm-hmm.
Do I need to be present for the January court date? I don't want to, I know they still called my name this morning for attendance, but I don't want to get in any trouble for not showing up.
Right, and you wouldn't get, you know, I just don't want to accidentally dismiss your case.
Okay, so if I need to be here, Your Honor, I can.
You know, I'm hoping that we can get him onto an income deduction order, but I hate to say it, but you know, it's been a little hard-headed. So, you know, if we need to do an arrest order, you know, I want you to be here because we really need it to happen immediately.
So that's my concern, because he's voiced to me that he's not interested in paying child support. So I know that when we come in the 19th, it's going to be the same thing.
Okay.
That was initially filed for the abandonment warrant because I tried to work with him. I sent him resources, I've sent him job fairs and so forth. But he's just totally against supporting financially, and that's why we're here. He was aware of the order from last month when you mentioned he needs to at least pay November and December.
Let me ask you something, because he's kind of implying that you're demanding that he take care of the children at the times that he needs to work. No,
it's not true. No, even the days that we have agreed, my son is in daycare. So he's never having to miss out on work for the care of
Oh,
our son.
okay. Okay.
Never.
So he's not physically taking care of him. He's just maybe picking him up and dropping him off from childcare
Yes.
as we do, and we don't consider that, that we can't work because of it. Okay, I got you. Okay, then. We will reconvene on January the 19th. And, and I'm sorry, I'd like to make it so that I can dismiss you, but I don't feel good about that right now. We might need to put a little bit of fear in them. Okay.
So what is the process of the arrest order?
When we do an arrest, he will just have to turn himself in. He will get a signature bond, and he'll be booked and fingerprinted and released so that he can go back out and work a job. So that's basically the process, but then it moves from my court into a state court setting. And I'm sorry, this camera is acting crazy again.
It may be the lighting, Your Honor.
It could be. I just don't understand it. It's probably some crazy way that the sun is hitting the camera. Okay,
so
anyhow.
My prediction, even with knowing him, is that he's thinking that it's going to continue to be reset and reset and reset.
And it won't. I mean, I give you a certain amount of time, and then I have to move on. We can't keep doing this. But, but I will say he does seem to be a little bit closer. Now he's not arguing so much about, the child care issue. He's asking for an income deduction order. So I think we're moving forward.
In a way, because my challenge with that is that he is seeking new employment. So which means when he seeks a new employer, they won't be able to collect from this previous employer, or knowing him that I do, he won't go to work.
Okay. Well, we have systems in place for all of this, but we try to give, we try our best to give everyone the benefit of the doubt and give them the opportunity to be a parent to their child. Did he legitimate his child?
No, I've encouraged for that process.
And that's something else, because I'm listening, and I know you already know this, but I'm listening to all of this about how much he cares for his child, but he needs to legitimate his child. I mean, and that way he will get legal visitation. So all of this right now is just something arranged between the two of you.
Yes, I provided him with a printed out documentation for him to legitimize his son. I don't think that he thinks that he has to, which I don't place restrictions in terms of visitations and when he wants to see him. But I've also encouraged him to legitimize both of his children. He has another pending child support case, but just giving him education on what that looks like, why it's beneficial for him. Even though I give him full access, even when it comes to medical visits and all of those things, but he won't legitimize.
So let me just, and of course, I'm not going to encourage anything that, your child, that's bad for the child, but sometimes it's better to withhold visitation and make him come forward to the court and do it the right way, because otherwise they just don't do it. And it is important for the child, mentally, right now the child is still young, to know that their parent cared enough to legitimize. And if something were, God, if something were to happen to him, if his parents were to say, I never saw that kid before, I don't know who that is, your child literally will have no recourse to get any kind of insurance, any kind of benefits, anything from their father. So it is important that they legitimize and, and take it seriously. Okay, but that's up to you. Okay, but I'm going to go ahead and dismiss you to come back on the 19th of January, 2024. I will see you again.
Thank you for having my calendar, and I'll see you next year.
Next year. Okay, then. Bye-bye.
Bye.
Yeah, the judge wasn't buying the whole I can't afford child support because I have to support my kids 2 days a week when I have them. She was not buying that argument. Oh, and every other weekend, don't forget. Deadbeat dads just annoy me. But yeah, I'm not a fan of that part of it. But she did say she had questions before he had left, so I don't know. The judge was careful not to give any additional legal advice or anything like that, so I don't know the legal aspect of whether or not the conversation that they had was okay or not okay. It didn't sound like anything that was, like that the judge did anything wrong, but it very easily could have gone to that place. So I agree that he should have still been there. But all right, guys, I'm getting tired. And I would rather sleep in my bed than on my stream. I love you all. And I'll see you again soon. And don't forget Dolphin's birthday's today. So make sure to wish her a happy, happy, happy birthday. Yeah, no, the judge already had her mind made up. All right, guys. Guys and girls and especially Philip Heels. Since we've all said goodnight to him about 12 times tonight. I'm just used to it. I know that when he says goodnight, he's not the one leaving. He's always just saying goodnight to other people. But I always get a kick out of it because everybody starts saying goodnight to him as if he's going away. And I think he does it on purpose because he's a little prankster like that. He's a jokester. Just got to get used to him. All right, everybody. You know the drill. If I can get my mouse to work over here. There we go. Be safe, be well, and much love.